time before we have other meetings we have to be to. I'm Senator David Hinkins, and I'm a co-chair with Representative Kevin Stratton. We'll both be making some comments. Afterwards, we'll have Senator DeBacchus would like to make a comment, as well as I think Representative Briscoe. And then we're going to go ahead and have the legal services team give an overview real quickly if they could, and then we'll go ahead and go to questions and answers, and so we'll kind of make that quick. I'd just like to say how much appreciation I have for the commission that I've been appointed to be upon by our Senate presidency and leadership, that I can be a part of this. Living in rural Utah, you actually see the impacts a lot more than you do possibly living in the Salt Lake City area, when your livelihood depends upon a lot of the land that's there, and in some of the counties is 90% in the areas that I live at that's owned and managed, and so it's a bigger impact on some of us rural, and it's a delight to hear our team of legal team to come up with their analysis of what they concluded, and our vote today to continue to pursue the legal action that we may have against to take possession of the land. And I'm thankful for them. I know that they're a great team that we put together, and that they put together, and we would just like to, I know that they've done this at a discounted value of what their normal rates are, and we're just grateful for them to be here, and so we'll turn some time over to Representative Stratton.
Thank you, Senator. We have gotten to know each other real well. I know when he travels and when he's home and where he is generally every day over the last several months, and it's been a pleasure to work with the good Senator. As we look at things from a 30,000-foot level, I think we agree that we want clean air. We want healthy and productive lands. We want to have access to those lands. We want things that we treasure cared for, not only for our day, but for the decades and generations yet to come. As we look at the opportunity to perhaps analyze who may be best suited at this time now to manage those lands, it's always helpful and strengthening to look at the successes that our good state has, the management that's acknowledged across the nation, the fiscal responsibility that's acknowledged across the nation, and all the good things that are happening within our state. Yet we do have challenges. We have challenges with education funding. We frankly have challenges here along the Wasatch Front with the health and safety and welfare of the south slope of the Uintas. If there's a fire out there, that greatly impacts the quality of our water here. The health of what takes place in Kanab is closely tied to the health and what takes place in Bountiful. We're a state of folks that like to take personal responsibility, to be accountable, to be transparent. From my agricultural background, I've always found that it's helpful for me to walk in the orchard on Monday morning or Tuesday or any day in the morning. And if there's a bug or if there's a problem in the peach trees, that I address it immediately. I don't call someone on the East Coast to ask their opinion and send off a question that will be answered days later, because you can lose your whole peach crop if you don't act immediately. I think we have a record in this state that shows that we can manage and care for the treasures that we all value. I remember one of the most challenging circumstances we faced in as it relates to our public lands played out in the fall of 2013 when our national parks were closed. I was pleased the state of Utah had the financial wherewithal to offer to open those parks up and welcome not only citizens across our country but across the world to see these treasures that we so value. I am an avid outdoorsman. I love to fish and hunt and hike with my children and family and friends. And for these reasons, for our future, for clean air, clean water, the health and productivity of our lands, those reasons are many of the motivating factors that compel me to be engaged in this discussion, this very, very important discussion. We've been strengthened by a careful analysis over many years on many fronts and many different angles. There's probably not a House and Senate across the nation that's passed more legislation and more carefully studied this issue over the last several years than here in Utah. We appreciate the support and the dialogue that's taken place. Frankly, we appreciate those that see it a different way as well, because it's in the challenging of the theories that the ultimate outcome can be strengthened. And we saw some of that today in our commission meeting, the benefit of looking at different angles. But frankly, this should not be a political issue. We need to ask ourselves, what is best for these lands? And how can they best be protected and managed and strengthened as we go forward? And I would point you that are here today to the draft that the chairs have presented as guiding principles on how we would approach these issues. Again, I thank your presence here and appreciate the opportunity to work on this issue. I have great hope for the future, and how grateful I am that we have the opportunity to have a discussion and an opportunity to consider what is best for our state. What a blessing it is to live in this great country, in this great state. Thank you.
Mr. Chairman,
yes.
Is your commission expecting the AG to move forward with this lawsuit?
We have no idea what the AG is going to do. It's completely, those are the separation of powers that we value and protect. Our job would be to fund efforts if we feel so inclined.
It sounds like you're recommending that you move on a suit.
We are
original jurisdiction.
The motion today, yes, the motion today dealt with presenting a model complaint that the Attorney General could then consider. Yes.
I just want to ask, Elizabeth Roberts has handed me the invoice of the law firms involved with the study, and it's highly redacted. And I was wondering if you could speak for reduced transparency with the involvement of the legal team.
We're seeking to be completely transparent on the amount that has been spent. As you know, I used those terms. There's a sense there's some confidential information there that needs to be protected at this point.
Right.
The 502,000 figure, 502,000, does that include everything that has been paid to the consulting firms?
No, it doesn't. The amount paid so far is $100,889,000. There's been $377,583 that has been approved and is in process. But it is the total amount committed to this point, yes. Be glad to take further questions, but we wanted to hear from Senator DeBacchus and then some of the legislative folks as well, and then we'll come back to questions if that's okay.
For those of you not used to covering the Utah Legislature, But that a little bit of fireworks is good. It's good for the soul, it's good for democracy, and too often we're just a legislature of kind of, that kind of votes. I like it, and I appreciate both of these men as chair. I mean, there are other chairs that would just stomp everything down, and I think it's healthy for where we're going. I want to briefly mention two things. First, the thing the lawyers simply didn't bring up, and it, as far as I'm concerned, is pretty irrefutable. And they're going to explain all the reasons why, and I'll bring in John Locke and the Magna Carta and all the rest. But look, there was an enabling act. This is an agreement that the state of Utah made to the feds when we became a state. It's the contract, it's the agreement. Whatever implied right of God we had before, we signed a deal. This is part of why we were a state in the United States. I'm just going to quote 2 sentences from it. This is what the gotcha is, all right? The state of Utah agrees to declare that they forever, F-O-R-E-V-E-R, disclaim all right and title to the land we're talking about, the federal land. Now, it's as clear as the nose on my face. And to those people who so passionately believe in intent language and literal intent, there it is. It's ungo-aroundable. That's why most scholars say you're not going to win this. It's not going to happen. You can spend hundreds of millions. It's not going to happen. There it is. And what would happen if it did happen, with every state saying we have claim to go take all the federal land, it would be utter chaos. I don't think it's ever, ever, ever going to happen. And I think it's right there. It's right in the document that we agreed to. Nobody had a gun in our head. There's the clause. There it is. And you're going to hear a lot of spinning and $500 an hour good lawyering, and I'm glad we get the best, and be it, but they're lawyers. There it is. And they're going to have an explanation. But go back to the enabling clause. There it is. That's point one. Point two, all right. This is one guy who is sick and tired of the bickering. This has been for the last 3 or 4 generations. We're fighting about this. And the reason we have lousy schools and our funding is so bad, it's because we don't have our land, and the reason we don't do this, and the reason we don't do that. I'm tired of all the excuses. A big report came out. I think it was a bit skewed because it was our state colleges and universities. They said, if we got all this land, what would happen? Would there be this giant boom? It was 800 pages. I know, I read that. You know what it said? Marginal. Marginal. And it didn't include the fact that, like last summer, the West was spending, the feds were spending $100 million a week on forest fires. A week. Now, all of this land if all of this land were to become Utahns, I'm not sure that would play into it. But there's a lot of responsibilities that come with that. And that marginal Utah would make some money if we got all the federal land, that came 85% from exploitation of fossil fuels. And my friends, it was based on oil being $90 a barrel. So I don't think economically it works. But am I willing to get this thing before the Supreme Court, to end it all, to shut it down, to have Utah take responsibility for running the state in the parameters we have? Yes, I am. And if I could be convinced, but I'm not convinced, that this case was actually going to be there and it's not some political thing, then I would be there. We brought this to the Attorney General and he killed it in my legislation, but we do need to end this as a society and as a state. We've got to get there. And we need those 9 justices to make the final decision, and it's probably going to be, you know what, you ain't got nothing, next case. In which case we'll move on and we'll accept responsibility for running our state and end this as an excuse, and we'll start funding education and doing the other things. So I am not wild about this. I voted against it I don't think the Democrats have had enough say. We haven't seen the documents. We don't know what's going on. And I think $14 million is a lot of money. But if we have to get it, let's get it done fast. Let's go to original jurisdiction, and let's get this thing decided so we don't have any excuses anymore. Thank you.
Thank you, Senator. We'd like to invite Representative Joe Driscoll to and then we'll have our legal service team.
I've never been paid by the word. As Senator DeBackus has, I was a public school teacher and I just got a flat rate. I'll try and be brief. I'd like to express my thanks to Senator Hinkins and my thanks to Representative Stratton, who are open, who are willing to listen, and I've appreciated their kindness and their management of this commission. There are 9 well-qualified attorneys on the U.S. Supreme Court, and they come to different conclusions looking at the same facts and making the same arguments. And I kind of like that system. And I trust that the men who put this together and their support teams know what they're talking about, and they have expertise. And their best guess is it's a $14 million proposition. And it could be more money. I think that's worthy of discussion. And I have some attorney friends that I'm going to be showing this to, and they'll give us, and that's the best way to test a proposition is to test its strengths by probing, as we have already noted. I would like to see the Commission for Public Lands refocus itself. I would like to see the Commission for the Stewardship of Public Lands talk about what stewardship of the public lands means. If Utah took over the Manti-La-Salle National Forest or the Wasatch Cache National Forest, if Utah took over millions of acres now being managed by the BLM, what would we do exactly the same as the Forest Service? What would we do differently? What would we open up? We heard one member of the commission say his goal for this lawsuit is to make sure that they can drill wells more easily with less oversight and much less application and get mineral extraction going much more quickly. That's what one member thinks. So how's that, if that's the dominant idea here, well, how does that play out? I think as a state body looking at committing tens of millions of dollars to a long path, which can be very exciting, we have an obligation to the citizens of the state of Utah to show them what that means, and I don't think we've done that yet. I really appreciate your attendance today. Thank you.
Thank you, Representative. We invite George Wentz and John Howard from the legal services team to come forward, and we also invite Professor Rotunda and Professor Seaman to come join us as well. Thank you. Thank you. And our just give a summary, if you would, for.
So, to start with, can we get the gentleman's names left or right?
Okay, Richard Seaman.
Oh, let me okay, Seaman.
Richard Seaman, John Howard, George Wentz,
Yep.
Jim Jardine,
We all know Jim.
Ronald Rotunda.
Thank you.
Okay. Rich is the administrative law and constitutional law expert. Also served for years in the Solicitor General's office. Has tremendous expertise in everything to do with the Supreme Court, how it happens, etc.
Yeah.
John is a constitutional litigator with years and years of experience. Jim is a extraordinarily well-known, well-seasoned litigator. And Ronald Rotunda is the author of the leading treatise in the world on constitutional law, as well as probably the leading book on ethics as well, which I failed to mention earlier.
We were too clear.
So, you know, to summarize our conclusions, just to be clear, based on our analysis, we feel that there are valid constitutional bases to challenge the federal government's near permanent ownership of the majority of the land within the state of Utah.
So what do you make of this notion, as Senator Baca said, that's kind of this legal Hail Mary? I mean, you mentioned that you don't think the U.S. Supreme Court will, issue order handing over public lands. What's the best case scenario for all this money the state would spend?
There is a possibility, as we stated, that under one of the theories, the equal footing doctrine, the Supreme Court could transfer title to the land to the state of Utah. That is a possibility. I don't want that to be lost. The original 13 colonies received their public lands. 6 subsequent states received their public lands. 19 states out of 50 states received their public lands. The admission of Utah was to be on an equal footing with those states, the original 13. So, in our discussion of the equal footing doctrine, we put a sort of a logic progression that I can point you to that I think sums that up. And I just have to find it. So, this is the logic progression of the equal footing argument, okay? 1, it is clear. Ownership of the unappropriated public lands rests with the sovereign as an inherent incident of sovereignty. History proves that. The original 13 states succeeded to ownership of the unappropriated public lands within their borders on independence. History shows that. New states are admitted on an equal footing with the original 13 states. That's a fact. That's a legal, constitutional doctrine that no one argues about. Utah, purportedly admitted by legislative text and constitutional imperative on an equal footing with the original 13 states, has been denied control and ownership of the same category of lands received by the original 13 states as an inherent incident of sovereignty. This unequal treatment impinges upon a variety of Utah's rights that the court has in the past recognized as sovereign rights. That's on page 83. It's a very logical progression. Could the court go with that? The court could go with that.
The best case, do you want to talk about the best case in FLIPMA?
Yeah, but if the court
Okay.
didn't go with that,
All right.
I mean, I understand that, but if the court didn't go with that, what could the state get out of this? What's the next level down and what's the end?
The next level down, and this is one we consider more probable, is that under the equal sovereignty doctrine principle that we discussed at length today, represented in the Shelby case, 2013, that the justices would conclude that the disparate treatment of Utah, as opposed to the states to its east, with regard to the ownership of land and dominion of land over land within their borders, is such a disparity that impinges upon the sovereignty of the state of Utah, that forever withholding that land from the state of Utah, as FLIPMA states is the policy of the nation, is unconstitutional.
And then under that, the state would get control of the federal lands?
No, there would be a ruling that the federal government did not have constitutional power to forever retain those lands.
The federal government, I think would,
Cover the microphone.
yeah, that is, I think what happened is there'd be a declaration, if necessary, an injunction that the federal government must engage in the regular disposition of the lands. They're not going to sell it all at once because that makes the price a little too cheap, but they will have to have a program to keep selling it, which is what they did for before we became under this Constitution. They did it for 150, 175 years. And so they have to go back to the old system. When that happens, Utah will get 5% of the proceeds. That's in the Enabling Act. And the reason, and we explained this in our paper, I think this is fairly clear, but you could read it yourself and decide. It's written for lay people to understand. We tried to, when we use jargon, we defined it. But I think the reason that Utah said it was giving up title was to make sure there was a clear title for the federal government to pass. That's what happened every place else. That is, Utah is assuring, when we become a state, Utah is assuring prospective purchasers, we're not going to claim that we have title, and therefore you could not get valid title from the federal government. And the federal government would then turn over the valid title, Utah would get 5% of the proceeds, and then the people that bought the land would do something with it, unless they just like to collect land as follow. And that would be something that would be helping the state and increase the tax base and allow people to live there. And to the extent the federal government has national parks, well, it keeps having national parks, has those in all the states. We're not going to be interfering with any of that. And there, I mean, I suppose it's possible for the Supreme Court to say, oh no, we were wrong in Coyle v. Smith. A state can waive its sovereign rights or can be admitted on the agreement to be a second-class state. I think that's highly unlikely that the court would actually do that. But it would be if Utah wins, I think what is more likely is that the federal government will be ordered to engage in the regular disposition of the federal lands, and you don't fool around with the federal court. If the Bureau of Land Management doesn't set up a program for sale, the federal court will do it. So I don't think that's going to be a problem. We had a case once, was it West Virginia and Virginia fought over who owned some debt. Was it this debt of Virginia? Well, the Supreme Court decided that case, and they didn't have to send U.S. Marshals that pillaged the land to raise money to pay the debt. We expect that the federal government will follow the statute. And I mean I'm not going to tell you we're going to win, because you never know. You know, when the Supreme Court decided that the Second Amendment applied to the states and guaranteed an individual right to keep and bear arms, it overturned an earlier case. So if you were just going to look at the cases, you'd say, well, that's not going to win. But they did, and they had very good reasons why when you read the opinion. So it's even if we have a 90% chance of winning, they're not 10 throws of the dice, there's just one. And so that becomes, but I do think it's a very solid argument. And if you read these papers, they're long, you know, but the argument is, the history is long. If you read it, you kind of wonder why the federal government hasn't been selling the land since 1976. And particularly since and the reason I think this hasn't become a national issue is the burden is not national. The burden is disproportionate on what I think 18 states. And that's why it's 20 states, right? 20? 12, I'm sorry, 12 states, yeah, not even a baker's dozen. 12 states, and 38, I'd say we're not interested, that's fine. 38 aren't interested, that's the great majority of the senators, the great majority of the representatives, and so it's not a national issue. If there is a lawsuit, if the Attorney General and Governor decide to go forward, it will, I think, become more of a national issue. Perhaps presidential candidates will decide that it's relevant. A lot that's going on now is the president has no idea about whoever the president is, because they work on a different level than the Bureau of Land Management, and that's just done by these people on a frolic of their own.
Let me make sure that it's clear to you. When you file a lawsuit, if that decision is made, you would have multiple claims in it. You could proceed under multiple theories, and most litigants would.
Inconsistent theory.
Yeah, and so you may well include it may be decided by the policymakers to include a claim under the equal footing doctrine for transfer of the land, but you could also move for a declaratory judgment that a section of FLPMA is unconstitutional. Under that theory, if you were successful, you wouldn't have a transfer of the land, you'd have an order of the court that the federal government now has to dispose of the land. The disclaimer clause would not be a defense to that, right, for example. And then the federal government would have to figure out how does it dispose of lands, and in theory at least, that may lead to a political solution between the federal government and the state. It's very complex, but does that help?
Yeah, it does
and
help.
look, another aspect of that, you know, we talk about what we're being very candid, what we think is more or less likely. We don't think it's weak. What we would not want is for the other side to say, gee, they even admit this argument is weak, so forget about it. Because that's not what we're saying. There are different theories, and we're making a prediction of what judges are more likely to go for, and they might decide to take one bite of the apple instead of the whole apple. For 200 years, we had a view of the president giving intercession appointments of federal officials without Senate confirmation that we thought was virtually unlimited. They did it. I mean, there was sometime, I think, at one point the Senate was not in session for like 2 minutes, and Teddy Roosevelt made like 100 decisions. Justice Potter Stewart, as I recall, was appointed to the U.S. Supreme Court without Senate confirmation as a recess appointment. Later on, the Senate came and recessed him. if you would ask the commentators what's going to happen, they can do whatever you want. That clause doesn't mean anything. Went to the Supreme Court. The president lost 9-0, with, I think, 4 of the justices taking the, I hate to say extreme doesn't sound good, but the more expansive view that would really limit the president's power. And the other 5 took the view that limited the president's power dramatically, but not as completely. I mean, if you ask most constitutional commentators, what about the property clause zone, they will either tell you, I haven't read it, or since we're talking about law professors, that doesn't prevent them from commenting that they haven't read it. They would say, yeah, the federal government do whatever it wants. But if you want to look at the law review articles of the people that have actually looked into it and written articles about this, and I'm not one of them, but if you look at the articles, there's actually the people actually looked at it, there's a fairly strong support. And it is, I think it's not Hail Mary, maybe it's an Our Father, I don't know. It's a football term, and my ex-wife said the only good thing about me was I took out the garbage and watched football. So I'm going to pursue that, but I do think it's a solid argument, but it's one the court's never thought about before. And that's what makes it a very dramatic case.
Look, can you speak to or just summarize really briefly? I couldn't quite get it in today's hearing. The significance of the recent Shelby ruling.
Well, that was a voting rights case, right? And the Supreme Court upheld the 1965 Voting Rights Act, which placed special burdens on certain states because they had been discriminating against blacks in voting.
Yes.
And the court upheld that. And in Shelby, what the court actually said was not, well, that's unconstitutional, but how could you possibly extend that for another 50 years based on voting rights, which are, that is the distinctions of voting, which are almost a half century old. And in fact, more blacks are voting in Alabama and Mississippi than in Massachusetts. So you want to use and then in the course of giving the reasons why, Chief Justice Roberts said, it's really significant when you treat one state differently than the others, that you require certain states to go to the federal government for permission to change its voting rights. That was okay in 1964 because you had evidence that was going on in 1964. What we find now is that you're extending it for a half a century based on rules that are about half century old. And that violates equal sovereignty. We cannot treat states differently unless we're enforcing Section 5 of the 14th Amendment, unless we're enforcing the Equal Protection Clause of the 14th Amendment and the voting rights of the 15th Amendment. And so there's an equal sovereignty of the states, which the court used as an important pillar of its decision. And they're going to ask, why are we treating Utah differently now? I mean, it makes sense to say we're going to sell this in a regular course, not do it automatically, because that's what we did when we sold land in Tennessee and we sold land in Kentucky. But when you got to the 104th longitude?
West Meridian, right?
104th meridian, suddenly the world changed. Yeah. Why was that? And that's what violates equal sovereignty. They've got to come up with not just why not, but a very good reason.
Yeah. Well, the states you're referring to, the East 100 Meridian, I mean, they're wall-to-wall arable land. You get west of the 100th, then some of the...
Well, you haven't spent a lot of time in the Appalachian Mountains, all right? Or in coal country.
But some of the land's not particularly useful without roads being built and irrigation and all this.
And that's something the state can't do right now. Yeah. That is, people, we had Elon Musk, I'm going to build my big factory. That factory will double the battery capacity of the world, right? And he's going to put it in Nevada, which doesn't have a lot of arable land, 80% of which is owned by the federal government. But at least they can get a road to him. They can get a road and train to him to cart out all these batteries, which are heavy. We couldn't. Now I say we. I've only been here since yesterday, but Utah couldn't do that. Utah doesn't have the ability to make that decision. Now, it might decide we want to do that. It might decide that we'd like to keep this the pristine the way it is, and that's the people of Utah. But the fundamental postulate of democracy is the people decide what the people want to do. And that was not only the postulate of our country, but that was the theory going back not on equal footing, which is an aspect of equal sovereignty. Equal footing is we'll treat the states the same. And so I think it's more likely for the court to say that the federal government must now engage in the regular disposition of land. And some of it may not sell for very much, and some of it may sell, but the state might decide they want to put a road there. But that would be the people of Utah would decide that.
Could you explain what categories of land would fall under these claims? Is it BLM and Forest Service, but not Park Service, or how?
Well, I mean, in every state, the federal government owns something. It's got its forts, right? It has got its national parks, and I think, what is it, like 4% of the federal land in Utah is national parks?
That's 7% of the federal land, right?
7% of the federal land. So
4% of the overall land.
4% of Utah, 7% of the federal land. So we're still talking about something like 59 or 60% of Utah is owned by the federal government, but not the national parks. I mean, we're not going to fill in some beautiful canyon or something like that. That's I suppose I can't imagine the people of Utah would ever want to do that.
Yeah. Well, how we keep hearing about all these enabling acts with that, that language, forever disclaim. The people of this new state forever disclaim title to these unappropriated lands within the borders. How do you get around?
Well, like I said, read the whole thing. It is, you're going to sell it. You're going to give us. I mean, I think this is the fair and natural interpretation. That is, we will give up our claims to the land, because after all, the settlers came here before there was before there was a state. It was just an area. We have our claims. The people will give up its claims to the land so that the federal government can sell it in regular course and give us 5%. Now, they say it in a pithier way, and but if you wanted to say it my way, that would seem perfectly reasonable. If you interpret it as saying we forever give up the right, and you don't ever have to dispose it and treat it as a second class, that would violate the equal footing doctrine, which says that's something the state can't waive. Another way of looking at it is true that the Enabling Act for Oklahoma said, we agree, make us a state, and we will not move our state capital. And a couple years later, that was them, this is me, we'd like to decide to move it. Well, you agreed not to move it. And the answer is, you have to follow the compact, except would that make you less equal? And if it would, the court said that that's invalid, because that's what the federal government would do all the time. There were people that said, one argument is, let's give special rights to the people, the first states that ratify. Because it wasn't clear. Tardy, Rhode Island, I think, was the last state to ratify. And it could have been the Switzerland of the New World. That would have been good for Switzerland, but bad for the rest of us. And so there's let's give special privileges to the ones that are going to that are do it right away. And the other delegate said it's something manifest destiny. They really felt from sea to shining sea. And you read one of the cases, 1813 is it, McCulloch v. Maryland. And Marshall says the framers envisioned a land from the Virgin Islands to the Pacific at a time when I think Denmark owned the Virgin Islands, and we weren't even in the Florida area. And at a time when we had just, I think we had just purchased the Louisiana territory, but the Indians there didn't know that. But they really had a sense that we have to go from sea to shining sea. That was our destiny. Yeah. And we want to encourage them to do that. And so we want to encourage them to want to become states and therefore become part of the United States. You have the Bear Republic in California, a separate sovereign, decided to become part of the United States. Hawaii, a separate country. Texas, a separate country. We'll give up all of that because we want to be part of you all, but not on a second-class rate. And that was something that one of the decisions we quote said that we would still have a free country if we had these, but we wouldn't be the country that the framers envisioned. And if courts know it can be second class, well, at least we'll have that one less thing to argue about.
I want to hit, okay.
I would just add one thing. If you read the whole sentence, it says forever disclaim until such time as they dispose of.
Yeah.
But I'd also like to hit this disclaimer clause, just a couple of issues, because we do cover it in the brief, as opposed to what was said earlier. And it's on page 83, but just so you're aware, number one, a state cannot waive sovereign rights. There's a long string of Supreme Court cases saying states cannot waive sovereign rights as part of their enabling admission process, okay? So if dominion over land is a sovereign right, as we have shown, there's a very solid argument there is, then the states can't waive that. So if it is construed to be a waiver, then it would be invalid. And there's a long string of cases that would say that. Secondly, disclaimer clauses, just in this exact wording, have never prevented the disposal or the transfer of land in the past. Louisiana has this same disclaimer clause.
Yeah.
It was the first state with this disclaimer clause because it was the first state where there were foreign titles. You had French titles, you had Spanish titles. So what they did is they set up a process for people with those claims to come in and clear them, right?
Yeah.
And then, right before admission, they said, okay guys, the gig's up, you forever disclaim those claims, right? So that's what it was for. Why? Because they wanted to sell the land. The federal government took that land over in order to dispose of it, right? They can't clear title. If you buy a house and somebody over here claims they have the title to the house, you cannot buy your house, okay? The deal can't close.
Yeah.
It's called a cloud on the title.
Yeah.
This language was put in specifically to clear any clouds on the title. So it's quite ironic that people say it is a bar to the transfer of land when it was actually included to facilitate the transfer of the land. Do you understand?
Yeah. Yeah, I'll refer to that. So here you have the states, so they're not asking the government, Utah's not asking the federal government to sell the land. They're asking the federal government to give us the land.
No. Two different theories, remember? You can plead two different things.
Okay.
There's
One
alternative
theory would be that, one would be to declare FLIPMA unconstitutional.
Right.
Okay.
And then they'd be forced to start selling the land. So
Well,
there's,
or they would,
Basically,
or
it's vulnerable on two counts here.
well, look, it might not be. Yeah, I'm sorry.
What the state is asking is for the transfer.
Yes.
That's different.
Not
than
selling
just
to
selling
private
the
folks. And you've made that very clear, that we're not here to
Right.
private the land. And yet you
So
guys
let me speak to
seem to be
that.
talking about
Let me
private.
speak to
There's
that.
precedents,
Yeah.
correct me if I'm wrong, there's precedents where in lieu of selling, they've transferred to the states.
yes.
Okay.
Let me speak to that because I want to be precise on this point. All right? Possibility under the equal footing doctrine that the Supreme Court could decide that Utah should be treated just like the original 13 states and 6 subsequent states were treated.
Yeah.
That's equal footing. We should have got what they got. 19 states got it. Why shouldn't we get it?
Yeah.
Could go that way, right?
Yeah.
The other way that they could go is we could say under the equal sovereignty principle that the discriminatory treatment, the unfair and unequal treatment of Utah as compared to these 38 other states is unconstitutional.
Yeah.
Because it impinges upon our sovereign rights. Why? Because you are not disposing of the land as you said you would to bring us up to equality with the original 13 and all the other states that have the land.
Okay.
There was a compact that they would do that, okay? Now, if I get a declaratory judgment action by the Supreme Court that declares a law unconstitutional, you know what has to happen? Congress has to address that law.
Yeah.
Congress has to address that law. It's not necessary that the Congress would all of a sudden say, oh, I have to revert back to some statute prior to FLIPMA. That's an assumption. No. What Congress says is, oh, I've got a hole in my law. What am I going to do? I don't have this anymore. I can't hold on to this land. I've got to do something.
Yeah.
Maybe I better go talk to the state legislature of Utah. Maybe I better work at a deal. Maybe I better get my state senators speaking to my congressional delegation in Washington, D.C. Maybe we need a statute that says what happens to this land. What happens when that takes place? Citizens of Utah are represented through their state legislators. All stakeholders come to the table and get engaged. A policy for the state of Utah is set forth. The map on page 71 or so of this thing shows how it's set out now. Would anybody set it out that way today? Is it reasonable to have all these little lands scattered throughout? Is it reasonable to have a state where you can't build roads? Is it reasonable to have a state where you can't run a telephone wire? Is it reasonable to have a state where you can't make broadbands? Would anybody do that if they had the ability to sit down and actually set forth a reasonable policy? If this aspect of FLTMA was declared unconstitutional, all of that could be revisited by all the stakeholders through a political process involving the powers in Washington, D.C. and the state representatives here in Utah to come up with a reasoned approach.
Good, thank you.
Thanks, guys, appreciate you.
Thank you.
Brady McCombs, AP. Nice to meet you. Quick question.